Greetings, everyone. This is Star coming back to you for some more life practicum with another TYSK episode. The topic for today sprouted from our previous episode regarding endorsements. But before we get started, let's review the lawful disclaimer. This is not legal or financial advice, but public knowledge that we were too lazy to find out by not reading and studying. Doesn't help that we didn't know what we didn't know, but now that we know better, we are going to do better. This is for informational, educational, and geek entertainment purposes only. Remember, do your own research, trust your own discernment, and take personal responsibility and liability for your own actions or lack thereof. Now, back to pleasure. What does it mean to endorse? Well, in everyday life, the term endorse denotes a verb which means an action of supporting someone or something. Kind of similar to like an athlete endorsing a name brand clothing line or a shoe company. However, the less verbal denotation of the word is a synonym for physically signing something. Most people use the word sign unless you're at a financial institution, then you may come across the word endorse being used, which technically means to sign the back of something. Now, you may have seen endorsement spelled either with an I or an E. There's all types of speculation as to why the change, but let's look at its historic use. The term endorsement comes from the old French word endorse, meaning to write on the back, which is how we should know where to sign because it literally refers to the act of signing or writing on the back of a document. And that document, it can be a check, a bill of exchange, or a promissory note. And this is done to transfer ownership or to approve the document, thus encompassing both definitions of the term. Now, endorsement spelled with an I was historically an alternative spelling used mainly in legal context. Some legal authorities preferred this form because it emphasized the in prefix, which implied an internal or formal action. The use of endorsement with an I was common in older legal and financial texts, especially in the 18th and early 19th centuries. This form was seen as more proper in the legal realm. Over time, endorsement with an E gradually replaced endorsement with an I, both in legal and general usage. And by the 19th century, endorsement with an E had become the dominant spelling, and endorsement with an I became increasingly rare. The change was influenced, of course, by the growing standardization of English spells. Spelling. And again, it was preferred because of its more simpler or phonetic form, so they say. Now, to spill the tea, hearsay has it that endorsement with an I refers to an individual action, to where endorsement with an E refers to corporations. But I have yet to find that inscripted in black and white. On to present day shenanigans. Henry Campbell Black, for those of you who don't know who the original author of the Black's Law Dictionary, he's from the 1800s, but he said to endorse with an I was a technical term to assign or transfer property title to another. Now, the party that endorses it can be the payee, meaning the person receiving it, a drawee, meaning the financial institution or the person paying the payee, an accommodation endorser, which is a person signing as a third party that endorses or guarantees the liability of debt on behalf of the other party, or a holder either in due course, meaning they're specifically named or a specific party to the transaction, or a bearer, meaning one who just so happens to physically have that instrument. So, in layman's term, one who signs the back of a check, bill of exchange, or other instrument to assign or transfer their property to another is an endorser? Now, some things to think about. When we gift the check to the bank by depositing it and we just give a blank endorsement by signing the back, can we truly be upset when they keep or hold the funds outside of standard banking practices or if they should happen to go under? I mean, technically, they're only giving us IOUs anyway, while they invest the cash controlling the stock market and using it for fractionalized lending. Not to mention, have you read your depository agreement? Just wondering. All our lives, we've been giving gifts away. So, if you didn't intend to be extra generous, then I think we need to endorse proper endorsements. Get it? Endorse proper endorsements? Okay, enough with the geek stuff. Now, earlier, we learned that the word endorse is another term to use for the verb to sign. In today's age, you may endorse with a good old wet signature or wet ink signature, a digital signature, or simply an X or a squiggly line. But that is referred, or let's say, set aside for those who are physically incapable, meaning they can't read or write. They can also use the X or squiggly line, or they only can use the X or squiggly line. But the caveat is they still have to have the full mental capacity and knowing to contract, even though they can't read or write. I wonder how that works. But anywho, have you ever been forced to endorse or sign in a particular manner? And when you ask why, they said, oh, I need your legal signature, or just your first and last name, or you can't use those protections, or I need it to be stylized because print doesn't denote a signature. Obviously, it means cursive, even though they aren't even teaching that in some schools today. Now, if you wondered why, it's because you are transacting as a third party of interest on behalf of your ens legis, meaning your public franchise entity, which some call a straw man. But it's a public version of you representing the corporation or your estate in all capital letters. And your estate is the only thing that can do business in the public because public and private cannot mix. You, the flesh and blood man or woman, cannot do business with a corpse. I mean, corporation, that is. But just so you know, the Uniform Commercial Code, Section 3 401, says that a signature may be made manually or by means of a device or machine, and by the use of any name, including a trade or assumed name, by a word, mark, or symbol executed or adopted by a person with present intention to authenticate a writing. In other words, you can sign however you darn well please. The problem for the general public is that our fool system did not teach us the proper way to engage in intercourse. Speaking of which, if you are native to the Americas, research the Intercourse Act of 1790 and the Intercourse Act of 1834. You'll be interested to know what is said in those acts. And no, I'm not talking about the other definition of intercourse. I'm talking about the course of entering into commerce in the law of the sea. Get your mind out the gutter. But it is up to us to figure it out and change our course of dealing. So let's learn about some types of endorsements that there are and how we should apply them. Now, I did the research via the Black's Law Dictionary and, of course, Google Mania, just to compare the two, since, the almighty Google is often used today, even in business. But in accordance with both of those documents, I have compiled a list of endorsements. And here they are. You have blank or regular, special, full, quote, general or proper, conditional, irregular, qualified, and restrictive. So, beginning with blank and regular endorsements, This is how we were taught in our school system to sign our name from elementary forward. It is simply just your name. By the legal definition, a blank and regular endorsement are pretty much the same. But the almighty Google says that there's a difference between the blank and regular endorsement. Google says that a blank endorsement is when someone signs the back of a check without specifying a payee, meaning anyone in possession of the check can cash it, or they just sign it just to cash it. While a regular endorsement, often called a special endorsement, includes the name of the intended recipient, restricting who can cash the check to the specific person. Now, to me, Google's definition sounds a lot like our next type of endorsement, which is a special endorsement. This specifies a specific person who the instrument is endorsed to by using the phrase paid to the order of with the transferee's name. Now, you may transfer this to another individual or to another entity like a company, business, or a trust. This is the same as what's called a full, general, or proper endorsement. Now, according to Blacks, a full endorsement is one by which the endorser orders the money to be paid to some particular person by name, which consists merely in the name of the endorser written on the back of the instrument. It defines a proper endorsement as such endorsement as the law merchant requires to authorize payment to the holder of the instrument. Now, thinking about that, this could also be why merchants, companies, and service providers want you to endorse your signature in a specified way because this specific format allows them to transfer the endorsements in accordance with the global commercial standards. And remember, we're all just passing the buck. So, this is probably again why you are instructed to endorse in a particular manner. Moving on. Conditional endorsements simply have stipulations or other actions that need to be completed before endorsement is considered valid or recognizable. Particularly, this is useful in businesses where a payment depends on either receiving goods or services before the payment is processed in full or partially. However, you write the condition. Next, we have irregular endorsements. These are for my folks that like to think outside the box while following the rules with scribbles and sparkles. Now, this type includes also unauthorized endorsements, meaning signatures that are by an unauthorized third party, kind of like forging signatures. These are considered irregular endorsements as well. Now, qualified endorsements are often used by financial institutions and include the verbiage without recourse, which simply means that the endorser is not responsible for the payment if it's returned because of insufficient funds or it's just simply dishonored. Now, with those issues, the endorser bears no liability and has no guarantee that the payer will honor it. And this is a way that you protect yourself from liability. So I think we need to copy what the banks are doing since we are technically private bankers ourselves. Now, this next one, it's a juicy plum. Restrictive endorsements. Restrictive endorsements limit what can be done with a negotiable instrument by using restrictive directives to the financial institution, like for deposit only, or pay to the order of, or for the benefit of. This is done to prevent anyone from taking that instrument and its proceeds and transferring it. Now, here we have an example or a visual on how to restrictively endorse an instrument. And this is not law. This is just an example. Take note, folks. Here we have a example of an endorsement called an FBO, meaning for the benefit of. And it's when an institution or custodian is depositing a check on someone else's behalf. For example, like a parent depositing a check on behalf of their child, or let's say you get a check from your bank to another bank or mutual fund, it might have the payee as the name of the institution and then FBO to your name so that you can place it into your account. Now, with this type of endorsement, the funds are legally owned by the beneficiary or beneficiaries, not the account holder. So if you are doing an endorsement and doing an FBO on behalf of your child or another beneficiary, please be mindful that you have the fiduciary responsibility to properly account for those funds and proceeds because you're just endorsing on their behalf as a third party with no interest. Now, if you did read the slides, we did come across a few new terms, so we're going to review those now. The first new term is the term allonge. It's a French derivative. Now, ever wonder if we're really speaking English? Because a lot of our English words are derivatives of French and Latin and Spanish and German. But anywho, just saying. But the term allonge is a form that's attached to a negotiable instrument that has additional endorsements and signatures, or is used for transferring the instrument to the lender. Now, shout out to my folks at yourlaw.org and King Pickle of Pickletoria for revealing this to the people. These are just a few of the locations where I came across this term and its explanation or its revelation because we didn't know what was being done behind closed doors, but now we know. So thank you to those folks that are out there sharing this with the people. Now, our next term is novation. This one is Latin, meaning making new, renewal, or renovation, or as those in the construction industry call renovation. Today's application is simply means to alter or make something new or a new contract with the agreement of all parties involved. Some things to note is that a novation is different from an assignment because a novation involves the transfer of both the benefits and the obligations to a new party, whereas an assignment concerns only the transfer of benefits. And typically, if you're reading your contracts, like your mortgage contracts or your auto loan contracts, you are granting them the right to assign that to another party. Now, that assignment could be just a collection rights, which often happens with mortgage contracts. I'm sorry, those dead promises, or the assignment of the security interest, which that's rarely done because the original lenders like to keep the security interest for themselves because they trade it and they make 100 times more than what the value of the initial request for your own access to credit was. I'm just saying. But the second note is that a novation is different from a delegation. The effect of a delegation from the perspective of the obligee is that now two parties, the original debtor and the new party, are both liable to repay the debt instead of just the original debtor. And a novation, on the other hand, results in the discharge of the original debtor and the liability of only the new party, or the liability transferring only to the new party. And again, the four essential prerequisites for a novation to be valid is that there was a previous obligation that was valid, and all parties agree, which extinguishes the old contract and makes the valid new contract. Now that that is out the way, we are so much more intelligent. Now for some helpful tips and tricks. Stop signing shit with a blank endorsement. This includes what you think is just a pauper begging for scraps, i.e., applications. Stop giving them gifts that you don't intend to give. Here's an example of how to protect yourself as a power of attorney or another type of agent for your public entities. Always include the principal's name first, because this establishes that you are acting on their behalf. Use the word by, which indicates the agency, or i.e., the office that you are holding on behalf of that principal. So in this example, you can either write by, sign your name in POA, which denotes power of attorney, or trustee, or executor, etc., etc. So you always want to clearly state your agency after you have signed your name, after you have wrote the word by. And just as a reminder, as we reviewed in the trademark TYSK episode, this is how you would endorse for your trademark or trademarks. Take a mental note picture. Thank you, and thank you. That is it for this episode, my Tisketeers. If you do have any questions or would like to share a rabbit hole topic, please feel free to send it to largerlearning@gmail.com. And thank you again for your audience. Don't forget to like, subscribe, and share for more fun matrix hacks. And with the thought that you should know series. Take care now. Bye bye then.